Okay. Okay. So Professor David Kretschmer is with us, and he's an emeritus professor of constitutional law at the University of Jerusalem. I'll let you introduce yourself, and you can share the screen. I'll stop my sharing.
Okay.
And the floor is yours.
Well, thank you very much. I'm going to share the screen now. I hope you can all hear me. Just let me try to see whether I can do that. Okay. Good evening to everybody, and thank you all for joining us this evening. And it's my pleasure to speak to you on this very difficult subject at a very, very difficult time in the history of our country. So what I want to speak about is the government claims that they're suggesting some kind of legal reform. And of course, the opposition, and I put it out straight, I'm a member of the Forum of the Professors of Law for the Protection of Democracy. We are absolutely convinced that this is not just legal reform, it's actually a constitutional revolution. And I want to explain to you this evening why we see it in that way. I'm going to start off with some very basics, and it'll excuse me if I do repeat the basics. I'm sure that these things are all clear to you all, but I've had a lot of chugei bayit. I've been to many places in which I've spoken about this, and it seems that people do not always appreciate some of the basics that I'm going to be speaking about. So first of all, I'm going to say something very short about democracy, because the general feeling among the present coalition is that democracy means the rule of the majority, and that the majority has won the elections and they can do what they like. Now, this, of course, is a total misconception. Democracy is rule of the people, by the people, for the people. The people include those who happen to be in the majority at the moment, but of course, the people also includes those who are not in the majority and who are in the minority at the moment. Now, of course, we have to have a rule of how we decide questions in our society, and on most questions, the prevailing majority in the parliament, and which in the parliamentary system is also the government, they must decide many of the questions which arise. But the basic point, and this we have to remember, is that the power of the majority is never unlimited. And we have a number of criteria for deciding where the majority must stop. The first is the rule of law. Every government, and that's the first principle of the rule of law, the government must act within the law. The government is not above the law. The king is not above the law. We don't have a king, but the government must act within the law. The second point is that we have rules of the game. And these rules of the game should be neutral rules, which are going to apply whoever happens to be in power at the very moment. They should be agreed to and respected by all. And one side should never be allowed to change the rules of the game to their benefit. We should have rules of the game which are drawn up with the veil of ignorance. We do not know whether those rules are going to be the one way or the other way, in my favor or not in my favor, because I do not know where I'm going to be in the opposition or in the coalition at the time that we draw up the rules. And therefore, we're going to draw up rules which will be acceptable whether we're in the opposition or in the coalition. The third point is the question of human rights. In a democracy, human rights must be protected, especially the rights of minorities of all kinds. And in Israel, we have many minorities. And a fourth point, which is very, very important in the context of Israel, for reasons which I can go into later, we do have to have guarantees against corruption, that the government should not have the power to make decisions which are flawed by corruption. Now, another point, and I think it's a very, very important point which all should remember. At any given time in a functioning democracy, we have people who are in government and we have people who are in the opposition. We have people who support the government. We have people who oppose the government. But the people who oppose us are not our enemies. They're not traitors. They're not anarchists. They're people we may disagree with. We can argue with them. We can discuss with them. But they are not enemies. They are not traitors. And they're not anarchists. They may be anarchists, but the mere fact that I'm opposing the government does not turn me into an anarchist. So that is the first issue, the first point that I think is very important that I make. Let me see, I'm sorry, I just don't, okay. So now the question that we have to ask, and that is the fundamental question that arises in relation to all the proposals of the government, is how are we going to ensure that there will be no abuse of governmental power? And of course, we're all familiar with the term checks and balances. But what is the question? How do we ensure that the majority will respect the limits on its powers? How do we ensure that the individual will have an effective remedy if his or her rights are violated? Now, of course, we could say, well, the law provides that the government has to keep the law. But we all know that that is not good enough. All of us remember those kind of regimes which had wonderful constitutions. They may have had wonderful laws, but there was no connection between the laws and what happened in practice itself, because there were no institutions to make sure that the law was enforced, especially against the government. So the most important point is, how do we create credible and effective institutions for the enforcement of the law and for the enforcement of the checks and balances and for the restrictions on the misuse of power? Now, if we look at the situation in Israel, and I'm going to later compare the situation in Israel to the situation in other countries, because very often the argument made by the proponents of the reform is, oh, we're only copying what they do in other countries. The point in Israel is that the only institution that we have is the institution of the courts, at the head of which is the Supreme Court. And if these courts are to fulfill their function in maintaining democracy and ensuring that the majority will respect the rights of the minority and will not misuse their power, not abuse their power, the judges must remain independent. If we have a situation like you had in certain countries not so long ago, and which does exist in certain countries today, that judges are dependent on the government or people who are supposed to be associated with the government, it's clear that we will not have credible institutions for the enforcement of the restrictions on governmental power, and the courts will lose all credibility in the eyes of the domestic public and also of international institutions. Now, often when I've debated these questions with supporters of the government, they've said, well, what do you want? We have the Knesset, and the Knesset controls the abuse of governmental power. There are a number of problems with this argument. The first is that, in actual fact, we don't have three branches of government in Israel. We have two branches of government. We have two branches of government because the executive has almost total control over the Knesset, which is enshrined in the coalition agreements. If you look at the coalition agreements which were signed between the Likud and the other parties in the present coalition, they claim that all members of the coalition must support all proposals by the Minister of Justice. When those agreements were drawn up, the members of the Knesset couldn't even know what those proposals were, but they undertook to support all those proposals. So in actual fact, we also have the governmental committee on legislation, and legislation is never going to get through the parliament unless it's approved, first of all, by the governmental committee on legislation. But a second reason why we can't only rely on Parliament is that I'm not only talking about the majority in the Knesset at the moment, but any majority in any parliamentary regime may easily lose the rights of individuals, of minority groups, or of the minorities themselves. They have a majority in Parliament. They may not be so sensitive to the rights of minorities. And then finally, we are talking about protecting, in many cases, the rights of an individual. Parliaments are not forums for providing a remedy to an individual. They don't have the power to do that. They do not have the capacity to do that. We do need other institutions. And I just said the only institution we do have in Israel is the institution of the courts. Now let's say something about the Israeli system of government, because this is very important in appreciating the problems that we have at the moment. First of all, Israel has no entrenched constitution. As you probably all know, the Declaration of Independence of the 14th of May, 1948 stated quite plainly that Israel would have a constitution which was to be drawn up by an elected constituent assembly. The Constituent Assembly was indeed elected in January of 1949, but it converted itself into Israel's parliament. Instead of drawing up a constitution, it became the Knesset, Israel's parliament. And when the opposition at the time, which was what is now called the right wing, it was at the time the Cherut party, but also the left was the communists, they demanded that the body which had been elected as a constituent assembly fulfill its functions and draw up the constitution. A compromise was reached, which was known as the Harari Resolution, because it was suggested, proposed by a member of the Knesset called Yizhar Harari. And that resolution said that the Knesset would not draw up a constitution immediately, but that the constitution would be drawn up in a piecemeal fashion, in basic laws, which would be passed by the Knesset and would each form a chapter in Israel's constitution. Now, after the first Knesset was dispersed, in the second or third Knesset in 1958, the first basic law was passed. That was called the Basic Law, the Knesset. And since then, a whole series of basic laws have been enacted, including most of the basic laws dealing with the branches of government and 2 basic laws dealing with the protection of certain fundamental rights, the most important of which we all know is the Basic Law on Human Dignity and Liberty. Now, from a constitutional point of view, we have a tremendous problem here. Our problem is that there's no distinction between 2 bodies, the legislative body, which deals with general legislation in order to give effect to the policies of the government in power at the time, and the Knesset as a constitutional body, which draws up the constitution, which fundamentally is supposed to lay down the neutral rules of the game for everybody and to protect human rights. And this creates tremendous problems. The second point is we're at a parliamentary democracy, but unlike most other parliaments, we only have 1 house of parliament. In most of the other democratic countries, there are 2 houses of parliament. The upper house, sometimes if it's a federal system, they're elected on a different basis, but there's some kind of checks and balances between the 2 houses of parliament. Israel lacks many of the common checks and balances which exist in other democratic countries. As I said, we have no rigid constitution. We don't have 2 legislative houses. We don't have a system of a presidential veto on legislation. We do not have a federalist structure so that power is dispersed among different bodies. We do not have regional elections so that the members of parliament are responsible towards to voters in their election. We are not subordinate to some kind of supernatural court such as the European Court of Human Rights. All the countries in Europe are parties to the European Court of Human Rights. We're also not party to a multi-level supranatural organization such as the European Union. The fourth thing is that when you have a stable government, it controls parliament. When you have an unstable government, like we had for 1.5 years, yes, the government may not control parliament. But once it has a fairly fair majority in parliament, the government has total control. But what we do have is a relatively strong and certainly an independent judiciary, which in our system of government is the only effective check on the misuse or abuse of governmental power. So now let me see, what is the major components of the proposed reforms. I'll just mention what all the different components are, and then I'm going to speak about one or two of them more specifically, especially the issue of the election of judges, because this is the biggest bone of contention on which the parties who have been talking have never been able to reach consensus. So what do we have? But first of all, the first point in their proposal, and from their point of view, I think this is the main point of view of the government, is to change the system of electing judges in Israel so that the executive branch of government, or if you wanted, the coalition, will have total control over the election of judges. The second point is to restrict judicial review by the courts on a number of levels. First of all, to prohibit any judicial review of basic laws. The second, to dilute judicial review of the executive. To have an override clause, which would say that even if the Supreme Court were to decide that ordinary legislation was invalid because it was incompatible with the basic law, the Knesset could re-legislate that law and make it valid, notwithstanding what was written in the basic laws and notwithstanding the decision of the court. There's another way of undermining judicial review of legislation. And finally, there's an attempt to weaken the powers of the Attorney General and government lawyers. Now, I want to say that if one takes each of these components of the proposal as itself, while I would certainly oppose most of them, and certainly the question of the selection of judges, I could not say that if only one of these proposals was put into effect, we would have a major constitutional revolution which would undermine the democratic nature of the state. But when we put them all together, what do we see? We see a concerted attempt to concentrate almost all power in the hands of the executive branch of government without any effective controls. So now let's go for each point. Now, as I said, the selection of judges has become the bone of contention. And this was the thing that even the president of the state of Israel, Mr. Herzog, tried to find some kind of formula to solve the dispute, and it was immediately rejected by the government. So let's see what the position is. The present system of electing judges is one which has gained a lot of attention in the world. And the interesting thing is that many countries have tried to adopt the Israeli system and have found that the Israeli system seems to be a system which has a lot of appeal. Now, in the first 5 years after the state was established, judges were elected by the government. An attempt was made to have a balance between representatives of the different political strains within Israeli society. So you had a member of the religious community, certainly, and you had a person who was thought to be more associated with the right wing. But the members of the court, of the Supreme Court, and all other judges were indeed appointed by the government. But in 1953, as a result of pressure by the opposition, which was the right-wing opposition at the time, a law was passed to provide a different system for selecting members of the judiciary, of all judges, of all levels. And the basic idea behind this was that there should be representatives of the public, so that you would have a committee of 9 members and 4 would be politicians, 2 ministers and 2 members of the Knesset, but they would not be in the majority. You would have 2 members of the bar and the president of the Supreme Court and 2 other justices. So the professionals on the committee would have a slight majority. There would be 5-4, and you'd have to reach some kind of compromise between the political echelons of government and the professionals who were thought to be more capable of assessing the qualities of the candidates for the court. Now, it's interesting, if one goes to the Knesset debate at the time that this law was debated in the Knesset, the predecessors of the present Likud party, which was then the Chairut party led by Mr. Menachem Begin, opposed the system because they thought that you should have more members of the court on the committee. They said, what are you talking about? Why do you have 4 politicians? We can't rely on the government to appoint the judges. We should have 4 judges on the committee and only 1 minister. But that view was not accepted. And the final law, which has been in force since 1953, is a committee of 2 ministers, the Minister of Justice and 1 other minister, 2 members of parliament, where generally 1 is from the opposition and 1 is from the coalition. That is not written into the law. 2 members of the Israeli Bar Association, the president of the Supreme Court, and 2 other justices. Now, to be quite honest, for a long time, I do admit that the judges on the court had too much influence on the election of judges. One could say that there was a certain feeling among the public that the judges were only taking like-minded people onto the court. So in 2008, Mr. Gideon Sa'ar, who was the Minister of Justice in the last government, was a member of parliament then, and he's a lawyer himself. He proposed an amendment to the law, according to which, in order for a person to be elected a judge of the Supreme Court, that person, that man or that woman, would have to get 7 of the 9 votes on the committee. Now, the present proponents of the changes say this gave the judges a veto, but it also gave politicians a veto. It gave a veto to both parties. You could not get a person elected to the Supreme Court unless it had the support of at least 1 judge and at least 2 of the politicians on the committee. And this proved to be a very, very good system because it forced the parties to try to reach some kind of consensus and to find candidates who would be attractive and would be acceptable both to the professionals on the committee, the members of the bar and the president and the other justices, and to the ministers and the members of parliament. Now, when we came down to the president of the Supreme Court, ever since the first president, Justice Zmora, retired in the early 1950s, a tradition was formed that the new president would be the most senior judge on the court. And that is not written into the law, but that is a tradition which has been followed since the early 1950s. And it has proved to be a pretty good tradition. That doesn't mean to say that every president of the court has been a wonderful president. You're never going to have such a thing, but it avoids politicization of the election of the president and also some kind of competition between judges on the court for that position. And so the issue of seniority has been followed, and I think it's been very, very good in preventing politicization. The quorum needed for that committee is 7 of 9. If you don't have 7 members, you can't convene the committee. Now, I'm not going to talk about Mr. Levine's proposals because Mr. Rotman, who is the chair of the Knesset Constitutional Law Committee, put forward his own proposal, and that is already past first reading in the Knesset. So it's more likely that if the legislation goes ahead, the system will be the system proposed by Mr. Rotman on behalf of the Knesset Constitution and Law Committee rather than the original proposal of the Minister of Justice, Mr. Levine. Now, what is Mr. Rotman's proposal? Well, he suggests that there be 3 ministers, 3 members of the Knesset, only one of whom would be from the Supreme Court, the president of the Supreme Court, and 2 retired judges appointed by the Minister of Justice with the consent of the Supreme Court. Second point in the proposal is that there's no special majority for election of judges to the Supreme Court. An ordinary majority of 5 of the 9 members of the committee would be sufficient to appoint any judge, including judges on the Supreme Court. And the president of the Supreme Court would be elected by the committee. They would not need to follow the seniority rule. And the president need not be a sitting judge of the Supreme Court or of any court. They could appoint a person as president of the Supreme Court who had never been a judge. And finally, the quorum for that committee is, sorry, it should be 5 of 9. This is 5 of 9 of the members of the committee. It's my mistake. So what do we see here? We have 3 ministers and 3 members of the Knesset, only 1 from the opposition, so that you have 5 of the 9 members of the committee are members of the coalition. In other words, the coalition would have total and complete control over the election of all judges. Now, this will necessarily mean that fundamentally the government can appoint judges who are more likely to favor the government stand, who are going to be associated politically with the government, and who are going to be convenient for the government when you're talking about even review of legislation, but of course not only of legislation, of any acts of the government. This would also mean a total blow to the independence of the judiciary for a number of reasons. First of all, the most likely candidates to be judges of the Supreme Court have always been judges of the district court. As you know, we have 3 levels of courts in Israel. We have the magistrates' courts, the district courts, and the Supreme Court. Most people, most judges on the magistrates' courts would like to get to the district court and eventually possibly to get to the Supreme Court. And I have never met a judge on the district court who would not like one day to be a judge on the Supreme Court. Now, if we have a system in which the government has total control over the appointment of judges, one can understand that judges on the district court who want to be appointed to the Supreme Court would have to understand that if they rule against the government in certain cases that come before them, their chances of being appointed to the Supreme Court would be negligible, if not totally non-existent. And so this is going to have effect on the independence of the judges. And it also can have an effect on the independence of the judges to the extent that people will perceive the judges as being total political appointees. Now, I'm going to speak about what happens in the world a bit later, but that is the fundamental proposal. And we in the Forum of the Law Professors of Constitutional Law in Israel, we have made 2 fundamental principles which we think that in the Israeli political system have to be maintained. The first is that the government should never have total control, direct or indirect, on the election of judges. They should have a say, certainly, in the election of judges, but they should not have total control. And number two, in the highly politicized system that we have in Israel, we should not have a system in which politicians, whether of the coalition or the opposition, have the majority in the election of judges. That is the problem, I would say, with the president, Mr. Herzog's proposals, which he laid out last Wednesday evening, in which he suggested a committee in which there would be a majority of politicians, not a majority though of the coalition, a majority of politicians made up of members of parliament of the opposition and of the coalition, and they would have the power to elect judges without the consent of any of the judges or any other professionals. Now, in the Israeli political system, our greatest fear is that this will lead to wheeling and dealing between the coalition and the opposition. Doesn't matter which government we're talking about. I don't think it depends on whether the present government is in power or any other government. The notion will be that there will be kind of deals between the coalition and the opposition, and suddenly we will have judges. Everybody knows the one judge was appointed because of the support of the opposition and the other because of the support of the coalition, which will not be a healthy situation. Now let me take the next point. Judicial review of basic laws. Now, I'm sorry if I have to be a bit legalistic about this, but if something is not clear, please let me know. As I said, Israel does not have a formal constitution drawn up as one document. What we have are basic laws, which are regarded as chapters in Israel's formal constitution. But these basic laws were not drawn up by an elected constituent assembly. They were not put before the public in a referendum of some sort. They were enacted by the Knesset. Now, most of these laws are not entrenched. They may be changed by a simple parliamentary majority. There are some exceptions. For instance, the basic law, the government may not be changed without a majority of the members of parliament. There is 61 members of parliament, but that is not a very strong entrenchment because the government of the day, in order to be in power, must enjoy the support of at least 61 members of the parliament. So they do have the effective power to change that law. The biggest problem is that there is no definition in the basic laws or in any other law of what constitutes a basic law. And so up to now, the only thing that determines whether a law is a basic law is the title of the law. If the Knesset decides to call a law a basic law, that law then becomes a basic law. Now, the proposal of the present government is that there will be no judicial review of basic laws. Now, when looked at, removed from the context of the Israeli constitution, one could say, well, if basic laws are part of the constitution, why should the Supreme Court have the right of judicial review over the constitution? The problem is that the Knesset may term any legislation a basic law. For instance, if they want to appoint a corrupt minister as a minister, they can just make a change to the basic law and then say, well, this basic law is now immune from judicial review. If they wanted in future to give immunity to the prime minister from criminal action, they could change the basic law and say that an ongoing prime minister cannot stand trial. And if that's part of the basic law, the idea is that there will be no judicial review of basic laws. They're now having a suggestion that they will put in to a basic law that there will be no conscription of yeshiva students, and therefore will deny the court any possibility of reviewing the legality of discrimination in conscription of individuals in Israel. Now, this is totally unacceptable because it fundamentally gives the government the power to pass any legislation that it likes to call the legislation a basic law, and then to say, well, now this basic law cannot be challenged in the courts, even if it violates most basic rights or basic principles of democracy. In order to reach a situation in which we have no judicial review of basic laws, we have to have a basic law on legislation, which determines what can be in a basic law, what may not be in a basic law, and specifically lays down a special procedure for passing basic laws so that the given coalition at any time can't just pass a law, call it a basic law, and therefore exempt it from judicial review. Okay, the next point is that this isn't good enough. The proposal is to dilute the possibility of judicial review of legislation. At the moment, the court, by a simple majority of, if they sit in a court of 11 judges or 9 judges, by a majority of 1, they can decide that a law is unconstitutional. I must admit that after the first decision, or the famous decision of the court in the Mizrahi case in 1995, I wrote an article in which I said this is not really a good system. I don't think that one judge should be able to be determinative of whether a law passed by the parliament, which represents the public, is unconstitutional. And so I do think that there is a claim to say that you should have a slightly greater majority for declaring a law unconstitutional. For instance, in the German system, in their constitutional court, there are 8 judges. And now it seems peculiar. We are used to the idea because of a bet din, as we know, anybody who's learned Sanhedrin knows that a bet din has to be of at least 3 members, or afterwards you could have 21, you could have 71, but it always not an even number. But the idea behind the German system is that you could never have a majority of 1. You'd have 4 to 4, you'd have to have 5 to 3. So that would be a reasonable system. But the proposal of Mr. Rotman is that in order to declare a law unconstitutional, you would have to have 12 judges of the 15 judges on the court. However many judges are sitting on the case. For instance, there may be a judge who can't sit on the case for a conflict of interest or for any other reason. You would still have to have 12 judges to declare a law unconstitutional. Now, especially if the government is going to appoint the judges, this possibly means that it will be impossible at any given time to find a law unconstitutional. But that was not good enough. They also want to pass an override clause, so there's some noises at the moment they may drop this, that the Knesset may pass a law, that law will apply notwithstanding any basic laws or the decision of the Supreme Court. They try to base this on the Canadian system, in which there was a deal reached when the Canadian Charter of Human Rights was drawn up in the 1980s. They had a problem with the federal structure of the government, and that Quebec was not that keen to join the Constitution. And so a deal was reached that there would be an override clause in the Canadian Bill of Rights, which said that the parliament, both the federal parliament or the parliaments of the various provinces in the states, could pass a law which would be applicable for a certain limited period of time, that it would apply notwithstanding any things in the Constitution, but certain rights could not be overcome by that. The rights of equality, for instance, could not be overridden. So to take the Canadian example is not very persuasive unless you're prepared to have a whole Bill of Rights, number 1, and number 2, to exempt certain of the rights from any override clause. The third point of diluting judicial review is that we now have a court which has developed over the years in administrative law various grounds for intervention in administrative action. And one of the grounds is that decision is highly unreasonable. And I say it's not that the decision is just unreasonable. It has to be highly unreasonable in the sense that the court really thinks that there's really something that's gone wrong here and that decision should not be upheld. Now what they want to do is to do away with the unreasonable doctrine, mainly because in two major decisions, the court interfered in decisions related to the minister, or former Minister of Interior, Derry, not only as far as his appointment as a minister, but also in a previous decision, which I can go into later if people are interested. The next point, and possibly this is one of the most serious, is that we have at the head of the legal branch of the government, we have the Attorney General. The Attorney General is a non-political professional appointee, suggested, nominated by a special committee, but appointed by the government from nominees of that committee. The Attorney General is the legal advisor of the government. She represents the government in court. She is also head of the state prosecution. In each ministry, we have legal advisors of the ministries. These have up to now also been professional appointments according to the civil service rules. The proposal of the present government is that the legal advisors of the ministries will be political appointments, what is called positions of trust, which means that they can be fired and hired and fired at the will of the minister. But furthermore, the proposal is that the government and ministers will not be bound by the legal opinion of the Attorney General or of the legal advisors of the ministries. Now this, I cannot tell you what kind of an effect this will have on the way the government functions. Let me give you just a small example. Assume that we have a situation in one of the ministries in which they put out a tender for some work, let's say to build a highway or to build a bridge or to build something which involves a huge sum of money. And there are a number of people who submit proposals. And one person who's not very well known, but he's a respectable contractor, submits a proposal. It's the cheapest proposal. And the professionals have judged the proposal and said it all meets all the professional standards. The problem is that there's another proposal submitted by a major member of the party of the minister in that ministry. Maybe a basic financial supporter, a person who can get that minister a lot of votes in the primary elections for that party. The legal advisor of the ministry says to the minister, well, it's 100% clear. The legal position is that you have to give the work to the person who submitted the cheapest proposal, which meets the professional standards. The minister says, well, that's fine. I've heard what you say, but I've decided otherwise. The proposal will go to Mr. X. What can be done about it? Well, you could say that the person who lost is going to be able to go to court, but you know, that's an extremely expensive proposition, and the chances of winning in such a case are not very great. And so in my mind, this proposal that the views of the Attorney General and of the legal advisors of the ministries on legal matters will not bind the government and will not bind the ministers is going to increase corruption and certainly will probably endanger the rights of many individuals. That is not the end. In the pipeline, we have a number of proposals which are already being put forward by ministers or have even been submitted as private members' bills. One of the proposals is to abolish the independent broadcasting, which is the most, I would say, critical and objective of the media in this country. Greater political control over the police, control of academia, the suggestions of restrictions on civil society, taxing all contributions to civil society groups so that they will basically be forced out of action, widening of discrimination against women, trying to give immunity for all IDF and police actions, no matter what. And now the most recent proposal, which is being dealt with in the Knesset today, is to make it legal to give public officials payments in order ostensibly to finance either legal proceedings against them or their families, or even for their health needs. So you can imagine what this will be if people can now start handing over large sums of money to public officials. They don't even need to do it under the table anymore. They can do it quite efficiently. Now, one of the arguments. Sorry? Somebody asked a question? One of the main arguments of Kohelet and the other supporters of these proposals is, well, that's what they do everywhere else, so why should we differ? Now, to be quite honest, I, as a constitutional lawyer, think that there's a limited value in comparisons unless you compare. You have to compare so many factors that have to be taken into account that just taking one item and comparing it is of little value. It allows you to do pick and choose. For instance, I've already mentioned the idea, well, we like the idea of the override clause in the Canadian Constitution, but we don't like the idea that Canada has a Bill of Rights. So what we'll do is that we'll take the override clause without the Bill of Rights. Or another thing mentioned is Holland. It is true, in Holland, there is no judicial review of parliamentary legislation on the grounds that it is incompatible with the Dutch Constitution. However, the Dutch Constitution lays down that human rights treaties, which have been ratified by the state, have precedence over laws. So that in a case in which a court is faced with a law which is violating human rights according to major treaties to which Holland is a party, the court has to prefer the human rights treaties over the legislation of parliament. And Holland is a party to many human rights treaties, including, of course, the European Convention of Human Rights, but also the International Convention, the International Covenant of Civil and Political Rights, and the International Covenant of Economic, Social, and Cultural Rights. So you could say, well, we're going to be like Holland. We're not going to have judicial review of legislation. Well, that's fine. It's provided you take the other part of it and say, Israel is also a party to human rights conventions. Let's make them part of our domestic law and say that when there's a clash between legislation and the Human Rights Convention, the courts have to prefer the Human Rights Convention. But another point, and that's the most important point, the political culture is very different among different countries. You cannot compare a country, let us say like Great Britain, in which there's a long established democratic tradition, to a country like Israel, which is still a fairly new country, in which we have a democratic tradition, but one can't say that it goes back a very, very long time. Populism is on the rise in Israel. As we've seen recently, there's no respect for the rules of the game, and I say it for all parts of the political process, not anything. And yet, the one thing that I would say that people say, well, this is not done everywhere else. I do not know of any other country in the democratic world in which a person who's on trial for bribery and corruption can still be prime minister of that country. So if one wants to start comparing, I think there are certain other norms that we could also take from other countries. So now let's see, and this is where I'm going to end and open up for questions. What are the dangers of the proposed changes? Well, first and foremost, if they all go through, and even in part of them go through, we're going to give unbridled power to the executive. There'll be no checks and balances on the use of their power. There will be no effective rights protection for minority rights, for women, for the LGBTQ community, for Arabs, for you name it. We will have a system of backsliding. We can see the lessons from Hungary. You start along that thing and you end up and you've hardly got a minority. And I'm also very much afraid that this will increase corruption. As it is in the latest corruption index, which was published by the Transparency International, Israel was ranked 27 of the 35 OECD countries, the first being the least corrupt and the 35 being the most corrupt. I'm sorry to say that if these proposals go through, I hate to think where we're going to be on that scale of corruption in the future. Well, on that happy note, I would be very pleased to take questions.
Thank you very much. Maybe I'll first refer to questions in the chat that people asked while you were speaking. Ida Berger asked, but what if the majority does not accept the definition of democracy?
If the majority doesn't accept democracy, we're in a big problem. And then we're going to have a struggle, as we do have at the moment. And that's what's going on at the moment. There are large supporters of democracy in this country. The most interesting thing, I would say, of the Israeli system is that, opposed to other countries, in which very often opposition to democracy comes from the military, in this country, the militaries are the supporters of democracy. You saw, I don't know if any of you saw, but not only the militaries, all their former heads of the security service are the people who are most supportive of democracy. There was an interview last week with Ilana Dayan, when she interviewed the former head of the Shabak, of the Israeli Secret Service, who served under Netanyahu and has a lot of respect for Netanyahu. He's appointed by Netanyahu, who said, we are going to a dictatorship, and this will destroy the country. Now, you know, I accept there are some people in this country who do not value democracy. Their view to democracy is instrumental. I do not have a legal answer to that. I do think that if you have institutions which protect democracy, such as the given institutions that we have, your chances of maintaining democracy are slightly greater. But I had a professor of constitutional law. He was actually a well-known man called Benjamin Akzin. And he used to say as follows. He said, you know, countries that have constitutions, the constitutions are like locks on a door. When a small thief comes along and sees there's a lock on the door, he's going to go by and he's not going to try to break into the house. But if somebody comes along who's absolutely determined to break into the house, the lock will not prevent him from doing so. So in democracies, we have to have institutions, we have to have public support, and there's a tremendous public support at the moment for the democratic institutions. But there's never a guarantee that you're going to win. Unfortunately, we have too many historical examples of the opposite. But that's why many people, there were, say, 300, 400,000 people on the streets on Motzei Shabbat.
Another question is, what is meant by restrictions on civil society? You mentioned that.
Yeah, well, there are human rights groups, and one of the biggest proposals is to place a huge taxation on the contribution to human rights organizations. And that will fundamentally mean that they probably will not be able, they certainly will not be able to function on the level that they function at the moment. Funnily enough, they're not going to place the same kind of restrictions on the sums of money which are being pumped into some of the organization Israel by elements, right-wing elements among the American Republican Party and supporters, but only to those monies which go to civil society groups. Well, you had it that Smotrich said before he became the Minister of Finance and the Minister in the Ministry of Defense that the human rights organizations are an existential threat to Israel.
Another question by Barry Top. It is often said that the international respect and standing of the judicial system in Israel protects the military and others from international sanctions, the ICC in Hague, etc. What would be the red line in terms of the coalition's proposals which would cause us to lose the protection?
Yeah, this is a very sensitive question because there are two issues here involved. When you're talking about, first of all, the International Criminal Court, and you know that the prosecutor and the court has already opened an investigation into what is called the situation in Palestine. even if the court has jurisdiction and it has decided that it does have jurisdiction in this case, it cannot exercise that jurisdiction if the country which has the domestic jurisdiction of the persons involved, unless that country is either unwilling or incapable of putting that person to trial in a credible trial. Now, first of all, if there's a perception that the courts in Israel are not independent, then the idea will be, well, even if you put people on trial, it's not going to be credible. But number two, there's now a proposal before the Knesset, which in my mind is one of the most pernicious of proposals, which is totally opposed by the chief of staff, but that doesn't seem to bother the people involved, is to give total immunity to all IDF soldiers and possibly to the police in any action on the West Bank or in the occupied territories. Now, if that was passed, that would mean that Israel was not willing to prosecute soldiers or officers who are allegedly committing war crimes, and that would mean that the ICC would certainly be able to exercise its jurisdiction. Now, there's another possibility, and that is the possibility of universal jurisdiction. Universal jurisdiction is the exercise of the jurisdiction by domestic courts in other countries under the Eichmann precedent. That's the main precedent in international law. When Israel prosecuted Eichmann, he said, you don't have any jurisdiction over me because I didn't commit the crimes in your country, and I'm not a citizen of your country. And then a famous judgment written by the former president of the Supreme Court, one of the greatest judges in Israel's history, Justice Shimon Agranat, he explained that there's now a view in the international community that the court in every country has a jurisdiction to try people who are charged with crimes against humanity. But the same now applies to war crimes. Under the Geneva Convention, says universal jurisdiction, so that any court can try a person for a war crime if that person happens to be in the jurisdiction of the court. But one of the things that domestic courts do look at before they exercise this jurisdiction is whether the court in the home country is able and willing to try the person. So, for instance, the case against Sharon in Spain was eventually dismissed because the Spanish court said, well, you have independent courts in Israel, they can try him. If these laws go through, I'm not sure that the courts will decide as they did in the past.
Okay, last question in the chat box. I suggest afterwards, anybody wants to ask a question, just unmute yourselves. How could the current judicial system be changed reasonably? Does it have to be improved?
Well, I think number one, that one can't divorce the judicial system from the whole constitutional system. One of the things that the present government has done is that it's focused the whole problem on the judicial system, which is something that I totally deny. Now, I've written books in which I'm very, very critical of the courts and of the judges. And I'm not a person who's thought that the judges can do no wrong, and I think that there's a lot of need to change. But if I'm looking at the whole constitutional and political system in Israel, I would not start with the courts. One of our big problems is a problem I referred to the courts. We only have two branches of government at the moment. That the Knesset is not functioning as a proper body which has control as it's supposed to over the government. So the first thing that you have to do, if you really want to change the political system, number one, is to find mechanisms for strengthening the power of the Knesset as an effective institution to exercise control and supervision over the government, possibly through change of the electoral system, which has been on the cards for a long time. When it comes down to the courts, I think that there could be changes in the way of electing judges. I have no problem with that, provided that there's no majority for the coalition and even for politicians. So if you wanted to say, well, we could increase the number of other professionals on the committee in some kind of way to reduce the weight that the existing judges have, yeah, well, that could be examined. But the principle has to be that if you want to maintain the independence of the judges, they cannot be elected solely by the politicians. then one of the biggest problems of our judicial system is that we don't have enough judges. When you compare the number of judges per capita in Israel, we're very low down on the scale. So people have to wait a huge long time in order to have their case heard. And we're talking about ordinary civil cases or criminal cases. You also wonder why a criminal case like the case against the present prime minister should be dragged out for years and years and years. In most other countries, you start a criminal case and you can finish the case within a few months. So I think that these things could be overhauled and they could be changed. But fundamentally, what I do believe that if we want to consider changes to the present political and constitutional system, we have to have a wide discussion, a public discussion in which all parts of Israeli society are involved. Religious and non-religious Jews and Arabs, Mizrahim and Ashkenazim, women and men, to try to define in advance what the problems are, and then to work out some kind of proposals which will be acceptable to large parts of the population. You're never going to have total consensus, but the idea that a government which only got 50% of the popular vote in the last elections can suddenly change the whole political system is unacceptable.
Another question. Was Deri dismissed because of reasonableness or estoppel or shtick?
In the last case, there was a division of opinion by the judges on the Supreme Court. 3 of the judges decided that the question was a question of estoppel, and that he'd actually misled the magistrates court before which he was tried for tax offenses into believing that he was leaving the political system and that he would no longer be in government, and that he was sentenced on this basis, and that the court also did not decide, as it would have had to decide if he were a member of parliament, whether the crime involved was a crime involving moral turpitude, and therefore that Deri was stopped from challenging what he said before the courts. Some of the other judges decided the case on the grounds of total unreasonableness, which was following the previous precedents of the Supreme Court. The 11th judge on the court, Judge Elron, Mr. Justice Elron, where the press seemed to put across the opinion that he was in favor of Deri, he certainly was not. What he said is that according to the law, Deri was supposed to go to the chairperson of the elections committee in order for him to decide whether the tax offenses with which he were committed involved moral turpitude, and if they did, he could not be appointed a minister, and that obligation still applied, and that instead of now just dismissing the appointment of Deri, he said the prime minister must send the case to the chairperson of the elections committee in order to decide whether Deri's conviction was a conviction of a crime involving moral turpitude. But the question of Deri and reasonableness did not start there. The question of reasonableness of Deri started a long time ago. It started in the 1980s. And I don't know, I'm looking at the audience now, most of the people here seem to be closer to my age. I'm not sure how many football fans we have in the audience tonight. But those of you who do follow football in Jerusalem know that we have a stadium in Jerusalem, the Teddy Stadium. Now, there was a big saga in Jerusalem for the building of a football stadium. In the 1950s and 1960s, those of you who lived in Jerusalem at the time will remember that there were 2 small football fields, the one in what is now IMCA, the YMCA, opposite the King David Hotel, and the other was in Katamonim, a small kind of football field. Well, the population grew, soccer became more popular, and we needed a larger stadium. The problem was that the Haredi community in Jerusalem were totally opposed on ideological grounds to having a stadium. It was not a matter of where the stadium was, it was opposed on ideological grounds. So every time that a proposal was raised to build a stadium in one place or another, they managed to frustrate it until the site in Malcha was selected and the plans went through all the planning committees. I went through the local planning committee, went to the district planning committee, in which they're representatives of the Ministry of Interior, and eventually, after years, the plan was approved. The only problem was that, according to the law, in order to get final approval, it had to get the stamp of the Minister of Interior. And the Minister of Interior was Mr. Derry. Mr. Derry said, no, he's not going to approve that plan, because in order to approve the plan, he had to see an overall plan of the planning of the whole area and then see how it would fit in. Now, this is after years and years of planning, in which the members of his own ministry have sat on the planning committees. All the objections have been heard. And it's cost millions of shekel, at the time lira, in order to plan this. And now he says no. Now, it was quite clear that his real reasons were the reasons that he belonged to the Haredi community, and his community opposed it. This went to the Supreme Court, and the Supreme Court overruled his decision on grounds of unreasonableness. So I think that Derry has a bone of contention with the reasonableness going back to the 1980s.
Okay, another question, the question is, suppose the present new legislation is passed and the Supreme Court overrules it, and suppose the government decides to ignore the Supreme Court's ruling, what happens then? I'd like to extend that question, and I'd like to ask, as far as I understand, we have two crucial weeks now. Can you portray for us what you expect to happen in these 2 weeks, or what's supposed to happen in these 2 weeks? When expecting this question, so that's probably the end game that we're going to meet at the end of these 2-3 weeks or whatever.
Look, I'm not a prophet, and as we know, you know who prophecy was given to, so I'm not going to be a prophet to decide what the Supreme Court will decide. Many of my colleagues are convinced that if parts of this legislation do get to the Supreme Court will have no option but to overrule the legislation on the basis of various legal arguments which have been before the court before. So I'm not going to presume to know what the Supreme Court will decide. I do fear that whatever it decides, it will not be a unanimous decision. In the Derry case, the advantage was the recent Derry case that the court was unanimous. The press said it was 10-1, but it wasn't really 10-1 because the 11th judge also said that Derry has to go and get the question of his moral turpitude determined by the chairperson of the elections committee. So that would be a big fear. I'm not sure what the court will decide or could decide in the case. I think there's a reasonable chance that it would decide that at least part of the legislation is not constitutional on the grounds of a doctrine which has been used, which has never been applied by the court, but which is mentioned by the court in its previous judgments, that because we have the system in which the Knesset is both the legislative body and the body which draws up the constitution, you could have a situation in which the Knesset misuses or abuses its constitutional power to make a constitution. For instance, if the Knesset were to pass a basic law which had personal application, for instance, the basic law saying that Derry can now become a minister, I think there's a large chance that the court would say this is not part of a basic law. A basic law has to have a general principle. It can't have a principle which is applied immediately to an individual. I think that may even be the case if they were to pass a basic law saying that a prime minister could not stand trial and apply it immediately to Mr. Netanyahu's trial. I think there's a fair chance the court will say that cannot be part of a basic law. As far as the other basic laws, well, it's a big question. The most difficult question that you ask, and that's a question that I do not really have an answer to, is well, how will the various authorities act? I think we have clear intimations from the head of the police and from the former heads of the security service that as far as the police and the security service are concerned, they will abide behind the law. And the law is what the court says. And so if the court says that this is what the law is, they will support the law. There is no doubt. Well, it will not affect the military, but because in this country, the military is not going to deal with internal affairs. But as far as the police and the Secret Service goes, it seems quite clear that they will support the court. But you could have a problem over here. Now, to be quite honest, I don't think that this question is going to arise, because assume at the moment that the question that comes before the court is the question of the judges' selection committee. Assume it. I'm not saying whether the court would uphold it or not, but assume for the moment, just for the sake of argument, that the court were to say that this is an abuse of constitutional power. You cannot have a system of election of judges in which the government has complete control over the election of judges that interferes with the independence of the jury. Okay. Well, what is there to enforce now? You're not calling on the police. You're not calling on the Secret Service to do anything. What would then happen is that the Minister of Justice could say, well, I'm not going to convene any committee for the election of judges. Okay, so you're not going to be able to appoint judges, but there's nothing to enforce. The problem of enforcement is that these laws lay the grounds for passing other laws, which they would want to enforce. And that's when the problem is going to arise. I don't see the problem arising immediately in any case at the moment, because the laws are just laying the ground for future action by the government or by the Knesset.
Okay, another question. Why do supporters of the judicial reform circle back to the disengagement? Please explain how the court's ruling at that time influenced public opinion about the courts.
You know, I find it very, very difficult to understand the argument on the disengagement. The disengagement was a political decision made by the government, supported by parliamentary legislation. One of the ministers in the government at the time, the Minister of Finance, who voted for the disengagement, is the present Prime Minister. The court has never interviewed in what are regarded as political decisions of the government connected certainly with the conflict with the Palestinians, with the Arab world. Let us take an example. As you well know, the question of the establishment of settlements for Israeli citizens in the West Bank, which is regarded as occupied territories, is generally regarded by most international lawyers, certainly by the Security Council and the International Court of Justice and the International Committee of the Red Cross and Israel's leading international lawyers, as incompatible with international law. But the Supreme Court has never ruled on the question. It said that this is a political question. The dominant nature of this question is political, and therefore the issue is non-justiciable. It's not a matter for the court to decide. So what did they really expect of the court? That the court could decide that a major decision of the government, whether right or wrong, that's not the point. That it would undo a major political decision of a government regarding the management of the conflict with the Palestinians. It's inconceivable that a court could do so. I would say, they charge the court with being activist. The most activist decision of the court that I have ever read, and believe you me, I've read hundreds of decisions of the court, is the minority decision in that case of Mr. Justice Edmond Levy, in which he kind of intimated that he wanted to interfere with the disengagement. This is not a thing that the court in Israel or any other country would do. It would be unprecedented. So what did the court do in that case? It said, yes, but we can look at the question of the compensation. And we feel that the compensation being offered to the people who are being forced to leave their homes in Gaza is insufficient, and the government has to improve it. That was the most that the court could do. And so it does not, I have never understood why, instead of aiming their criticism at the present Prime Minister, who voted in the government for the disengagement, suddenly the court is responsible for not stopping the disengagement. It's turning things on its head.
Any other questions? I'll refer back to my question. What's the timeline now? What's going to happen in the next 2 weeks?
I'm sorry to say it, but I don't know. There are some views that I've read about that the government is about to make a tactical move and saying that it's delaying part of the program and that it is only going to go ahead with the program for the change in the election of judges, and that it's going to do this as a temporary measure so that it can appoint 3 judges of the Supreme Court, including the president of the Supreme Court. 3 judges of the Supreme Court are about to retire this year, so there will be 3 openings on the Supreme Court. What they regard as essential is for them to appoint those 3 judges. Once they do that, then they more or less have a close to a majority of judges who they think are sympathetic to their stand on the Supreme Court. So one of the possibilities is that what the government will do. Now, one shouldn't be fooled by this. This is not a compromise. It's absolutely not a compromise, because the question of the selection of judges is the main part of the government's program. If they have total control over the election of judges, they probably won't need the other parts of the program, because the judges will be subservient to the government, most likely. And so that is the one possibility. The other possibility, of course, is that Rotman and Levine, who seem determined to go ahead with their plan no matter what, whatever happens to the country, its economy, its social structure, and they will push this through before the Knesset disbands for the Pesach break at the end of this, the end of March, and then we'll be faced with all this legislation. I think that there will be a situation in which the demonstrations will certainly continue and they will grow. And I'm not sure what will happen then. The third possibility is that the government will fall. There is a possibility that the government will fall. There are already calls in the Likud. And from private conversations with members of the Likud, one knows that there's a lot of people in the Likud who are not keen on this at all. They're really not keen on this. They're not prepared to break party lines. But even Mr. David Bitan came out very strongly on the television and said, Mr. Netanyahu has to stop this. This is crazy. And there are other members of the Likud. Now, at some stage, just before we get to the precipice, some of them say, well, before we jump over the precipice, let's stop this. But I don't know, you know, your guess is as good as mine. I can analyze what the laws are. What's going to happen next is your guess is as good as mine.
Is there anything we can do except protesting?
Well, you know, I think that people have to convince everybody else that they have to oppose this. You have to write against it. You have to try to persuade other people. I am part of an organization of legal academics, and we are publishing position papers the whole time. We're trying to influence public opinion. Members of our group are appearing before the Knesset committee on an absolutely permanent basis. But you know, appearing before the Knesset committee is good for the public. It has absolutely no effect. They're not interested really in listening to what you have to say. The arguments are not even, I mean, even the legal advisors to the committee are telling them that you can't go ahead with this, and they're not listening to the legal advisors. They're not listening to the legal advisors, the Attorney General, to the Attorney General representative. Don't confuse me with the law. Don't confuse me with the facts. So what can we do? Yes, go on demonstrating. Go and demonstrate more and more and try to create greater pressure on the government to realize that it does not have the support of the public. Public opinion show that 62% of the public are opposed to these things, if whatever polls may be worth, and they're not worth very much until you get to the actual election, but they do know that if they were going to election today, they'd probably lose the election. And so you've got to keep up the pressure.
Okay, there's one more question. I think we'll end at that. Can the opposition do anything different?
And sorry, I didn't get that question.
Can the opposition do anything different?
Look, I'm not a politician. I'm a constitutional lawyer. And I am really not going to try to say what the opposition could do or could they not do. I do not think that they have fought very strongly against this. It doesn't seem to me that they've put up the kind of fight that previous parties in the opposition have done. There are quite a few members of the opposition in parliament, such as Gilad Karib, who's an excellent parliamentarian, and he's been very consistent in trying to fight these in the Knesset committees. But otherwise, I'm not sure that the opposition is being very, very kind of effective in its opposition. But as I said, I'm not a politician. I've never been a member of one of the political parties in the Knesset, and I concentrate on the legal academic side, and I've been, of course, active in human rights organizations, but that's not party politics.
I think we'll sum it. Any other questions, last questions?
Thank you so much.
Well, thank you all for listening to me tonight. I hope I haven't depressed you too much, but the good thing is that Israeli civil society has been mobilized in an unprecedented manner. One sees people of all types and of all walks of life and all political opinions, religious and non-religious, on the streets demonstrating. On Motzei Shabbat, I went with my partner, spoke at the meeting in Yavne, and there, which is a town in which the majority of people in the last election voted for the Likud, and yet there was a huge number of people, say 2,000 people there, demonstrating as well. So it's caught on. There are people in most of the towns of Israel for the first time in Israeli history very much opposing the government. It's a lot of ground roots public support, and it has to continue.
Thank you very, very much. Thank you all. I hope that by tomorrow this session will be recorded and you can see it in our YouTube channel. Thank you very much and good night.
Thank you.